Hello everyone, this is Dr.P.Syamala from the Department of MBA, International Business Management Studies, Acharya Nagarjuna University. Coming to our today's session, this is regarding to Doctrine of Ultra-Vires. So, what is the meaning of Doctrine of Ultra-Vires? And what is the concept of Doctrine of Ultra-Vires? And what were the consequences or effects? And also, what are the exceptions of Doctrine of Ultra-Vires will be studied under this session. Okay, so Doctrine of Ultra-Vires, this will be studied under the section of Memorandum of Association. In previous classes we have studied about Memorandum of Association. We all know that Memorandum of Association is a charter or else constitution of a company. Okay, so it is a written statement regarding the objects, aims and objectives of the company, or else the activities of the company, the relationships that is going to be maintained with the by the company with outsiders. Okay, so we all know about the Memorandum of Association. If we take Doctrine of Ultra-Vires, we have different 6 clauses in Memorandum of Association. In that, objective clause is also there. Under objective clause, okay, we will study about the Doctrine of Ultra-Vires. Why? Because Doctrine of Ultra-Vires concept is regarding the inability of the contract or else illegitimacy of the contract. Okay, means the contract that is entered by the two parties is considered as void according to the Memorandum of Association objective clause. Okay, so that's why under Memorandum of Association we will study about the Doctrine of Ultra-Vires, which is known as the contract is void. Okay, or else the company is not legally binding to the other party. So this is Doctrine of Ultra-Vires. Ultra, what is the basic meaning of ultra? Means beyond. Okay, see here, this is beyond. Ultra means beyond and vires means power. Okay, this means the power or else the authority of a company. And ultra means going beyond. Here we have to study the company, if at all, or else the agreement or the contract, if it goes beyond the Memorandum of Association, goes beyond the objective clause of Memorandum of Association, means it can be treated as the Ultra-Vires. Okay, means if the company does not act or enters into a contract beyond the powers of the company, okay, or else directors itself, then the act or contract is void. Okay, it is not legal and not legally binding on the company. So this is known as the Ultra-Vires. The company should act within the boundaries of the objective clause of Memorandum of Association. If the company acts beyond the boundaries of objective clause of Memorandum of Association, means it is treated, it is considered as the Doctrine of Ultra-Vires. Ultra-Vires means it is not legal, legitimate. Okay, so why we have to study about this Ultra-Vires? Means why? Means actually companies have to borrow funds from time to time for various projects in which they are engaged. Okay, so borrowing is an indispensable part of day-to-day transactions of a company. It has to take. Why? Because to maintain a company, definitely we will see assets and liabilities in a balance sheet, and no company can be imagined to run without borrowings from time to time. Okay, so we may find hardly, okay, without having liabilities, we may not see balance sheet of a company. Okay, so therefore there are certain restrictions while making such borrowings by a company. Okay, so what are those restrictions will be studied under this ultra vires, doctrine of ultra vires. If companies goes beyond their powers, okay, to borrow, then such borrowings may be deemed as ultra vires. So this is the concept regarding the doctrine of ultra vires. And for this there is a definition regarding the Companies Act 2013. So section 4 subsection 1 clause C of Companies Act 2013 states that all the objects for which incorporation of the company is proposed, any other matter which is considered necessary in its furtherance should be stated in the memorandum of the company. So if you see this section 4 subsection 1 clause C of Companies Act means it is related to the objective clause of memorandum of association, means the objects, the aims and objects should be according to the provisions of the Companies Act only. We should know the company should not go beyond the provisions of Companies Act. Okay, so here if at all, whereas section 245 subsection 1b of the Act provides that members and depositors a right to file a application before the tribunal, okay, before the court, if they have reason to believe that the conduct of the affairs of the company is conducted in a manner which is prejudicial to the interest of the company or its members or depositors, to restrain the company from committing anything which can be considered as a breach of the provision of the company's memorandum or articles. Both memorandum or articles can be considered provisions. Provision will be given according to the Companies Law Act, which is known as breach of provision of company. Means in some cases, in some situations, if at all the memorandum of association's objective clause has to be changed, okay, and that why the change can be accepted, okay, according to the provisions of company law, if at all, okay, that objects or else the reason for to alter the object will be safeguard the interest of the company, safeguard the members, safeguard the depositors, okay. So then in such cases a provision of a breach of provision of company's memorandum or article will be given according to the section 245 subsection 1b, okay, of Companies Act. So this is doctrine of ultra vires. Next, what is the purpose of ultra vires? Okay, so what is the purpose of ultra vires means it protects the interest of shareholders and creditors, okay. So this doctrine assures that creditors and shareholders of the company that the funds of the company will be utilized only for the purpose specified in the memorandum of the company. They will not act beyond the memorandum of the company, okay. So the investments of the company can get assured that their money will not be utilized for a purpose which is not specified at the time of investment, okay. So at the time of investment, if at all it is not specified means, okay, it will not be considered, okay. So basically doctrine of ultra vires means it has been developed to protect the investors and creditors, okay, investors and creditors, and it prevents company to employ the money of investors for a purpose other than those stated in the objects clause of its memorandum, okay. Why? Because the company could not go beyond the memorandum. It should act according to the company's law, provisions of company's law and the objects in the memorandum of association. So thus investors and company may be assured by this rule that their investment will not be employed for the objects or else activities which they did not have in contemplation at the time of investing their money in the company, okay. It enables the investors to know the objects in which their money is to be employed. Okay, by they can know, okay, they can know where their investments are going to be invested. Okay, and this doctrine protects the creditors, okay, regarding creditors of the company, ensuring them that the funds of company to which they must look for payment are not dissipated in unauthorized activities. Okay, so creditors of the company means who had given, who loaned to our company. Okay, so the loan taken by the company from creditors, okay, that amount should not be dissipated in unauthorized activities. Okay, so by this doctrine it ensures the creditors, okay, ensuring them that the funds of the company to which they must look for payment are not used inappropriately. Okay, and the wrongful application of the company's assets may result in the insolvency of the company, a situation when the creditors of the company cannot be paid. Okay, if at all unauthorized activities have done by the company means definitely company will get into insolvent. So ultimately creditors of the company cannot be paid. So this doctrine prevents the wrongful application of company's assets likely to result in the insolvency of company and thereby protecting the creditors. Right? So besides, the doctrine of ultra vires prevents directors from departing the object for which the company has been formed, and thus it puts a check over the activities of the directions. So it enables the director to know within what lines of business they are authorized to act. Okay, means it provides boundaries to the directors. So this doctrine draws a clear line beyond which directors of company are not authorized to act. Okay, company cannot act beyond the object clause of memorandum of association, or else the directors also, okay, they also cannot act. Unauthorized act will not be encouraged. Okay, so this is the purpose. So we can ultimately we can say that what is the purpose of doctrine of ultra vires means it protects, okay, the interest of the investors and creditors. It safeguards both investors and creditors. On investor side, how their investment is done, so where their money is going, where their money is invested, all the things will be known by the investors and also safeguarded. And coming to creditors, okay, so that creditors amount is used properly by the company or not can be safeguarded. Okay, why? Because if at all the company used that creditors amount misappropriately, okay, then definitely company undergoes insolvent. So in order not to go all these activities, so the doctrine of ultra vires safeguards the interest of say investors and also the creditors of the company. So that is the purpose of the doctrine of ultra vires. For this we can see two cases. Okay, for if we go for case 1, in the case of Ashbury Railway Carriage and Iron Company Limited, this is a company versus Rich. Okay, so the company and Mrs. Rich entered into a contract to finance the construction of a railway line. Later on, the directors rejected the contract on the grounds of it being an ultra vires transaction, and she filed a suit to demand damages from the company. Okay, so Rich claimed that the words general contracts, okay, general contracts in the objects clause of the company would include all kinds of contracts, and he argued that the company had all the powers and authority to enter into such kinds of contracts. Okay, so later the majority of shareholders of the company ratified the contract for financing the railway line. However, the directors of the company still refused to perform the contract. Why? Because according to them the act is ultra vires. Okay, and when this case went up to House of Lords, okay, the decision held by the House of Lords is that the memorandum of the company, okay, contract was ultra vires, the memorandum of the company, and it would be considered null and void. Why? Because the term general contracts was interpreted in connection with words of mechanical engineers, and it was held that the term only meant any such contracts that are related to mechanical engineers, and it does not include every kind of contract. Okay, why? Because general contracts, they when they entered into the contracts, okay, this mechanical engineers and general contracts, this statement will be there in the contract. Okay, so the House of Lords stated that mechanical engineers and general contracts means it does not applicable to any other contract. It is applicable to mechanical engineers only. This word general contracts is related to the word mechanical engineers. Okay, not for other aspects. Okay, for example, if they railway line, okay, so they should not enter into railway line. Basically, the company is related to manufacturing of the carriages, railway carriages, but it should not go for railway line. So this is separate thing. Okay, so that's why the House of Lords, they held that the contract is null and void. Okay, so this is the case regarding this according this Ashbury Railway Carriage and Iron Company Limited. Okay, here House of Lords stated that this contract is void. Okay, and coming to second case, Ivan versus Brunnermond and Company. Okay, in this case, company was incorporated for carrying on business in manufacturing chemicals. Okay, so the object clause in the memorandum of company authorized the company to do all businesses and things as may be incidental or conducive to the attainment of the above object or any of them. So in their memorandum of company, the object clause is regarding that all such businesses means regarding to manufacturing chemicals and things may be incidental or conducive to attainment of the above objective or any of them. Means by a resolution, directors were authorized to distribute 1 lakh out of surplus reserve account to universities for the purpose of research. So the directors of the company want to invest 1 lakh reserve surplus from the company for research. Okay, for scientific research regarding these chemicals. Okay, so the resolution was challenged on the ground that, so by having a resolution with the shareholders of the company, okay, they entered into this contract. Okay, so but this contract was challenged on the ground that it was beyond the object clause of the memorandum and therefore it was ultra vires. Okay, so the directors proved that the company had great difficulty in finding trained men. Okay, and purpose of resolution was to encourage scientific training of more men to enable the company to recruit staff and continue its progress. So the objective of the company going for this, okay, going for this means distributing the amount to or investing the amount on scientific research is for this concept. For what? Means for investing on trained men. Okay, why? Because to encourage scientific training and those and employing those people, those staff or else those men in their company, and to have a continued progress in their company, they are investing this. Okay, now what would be the judgment? Okay, or else what would be the statement given by the House of Lords? Means the court held that expenditure authorized by the resolution was necessary for continued progress of the company as chemical manufacturers and thus the resolution was incidental or conducive to the attainment of main object of the company, and consequently it was not ultra vires. In previous case we see that it is ultra vires and null and void. Why? Because the agreement itself is not correct. Okay, why? Because the company is manufacturing the railway carriages and entered into the contract of railway lines. So both are different. But here coming to in this case, okay, company is related to manufacturing of chemicals and invested. So this is related to the investors. In here we have studied the purpose regarding investors and creditors. Okay, so if we take this case regarding the investors, means the investors amount is invested, okay, on research, scientific research, but this is challenged, okay, challenged by the by this person on grounds that it is beyond the object class of memorandum. But the directors of that company proved that, okay, they are investing this surplus reserve of company in this aspect, in scientific research. Why? Because they have, as their company is related to manufacturing of chemicals, okay, they are finding it difficult to recruit trained men in their company. So for this purpose they are investing this money, okay, by resolution, encouraging scientific training for more men, and at the same time the company want to recruit that staff, okay. Why? Because to continue its progress. So here ultimately the statement given by the House of Lords, or else the decision given by the House of Lords, is that it is not the main object of the company, and consequently it was not ultra vires. Okay, so acts incidental or ancillary are those acts which have a reasonable proximate connection with the objects stated in the objects clause of the memorandum. This is the statement given by the House of Lords. According to this statement, so the judgment had been given. Okay, so these are the two cases. Even though ultra vires, in one case it is different, in the other case it is different. Okay, so we have to see according to the case. And coming to the effects or consequences of doctrine of ultra vires. So first one is void ab initio. This is the first thing, void ab initio. So what does void ab initio means? The ultra vires acts are null and void ab initio. Okay, these acts are not binding on the company. Neither the company can sue nor it can be sued for such acts. So that is known as the void ab initio. Okay, means if at all the company enters into any contract, okay, which is beyond the boundaries of objective clause of memorandum of association, means, okay, those acts are not binding on the company. Okay, so why? Because in memorandum of association itself we have studied that it is the responsibility of the outsiders or else the stakeholders to see the objects of the memorandum of the association, and then only they have to enter into contract, because memorandum of association is a public document and it can be seen publicly. So they can know each and every information in the memorandum of association of the company. So here in such case, okay, it is known as void ab initio if at all they entered into the contract beyond the memorandum of association. So these acts are not binding on the company, which means that neither the company can sue nor it can be sued for such acts. Okay, now second one is injunction. So what does injunction means? When there is a possibility that company has taken or is about to undertake an ultra vires act, the members can restrain it from doing so by getting an injunction from the court. Okay, so for example, if any company is going to misappropriately using the investor's investment, okay, so at that time, okay, the members or else the shareholders of the company or the investors of the company, they can restrain it from doing so by the company. How? By getting an injunction order from the court. Okay, so that is known as the injunction. So this is another consequence or else effect that can be seen by ultra vires. Okay, so ultra vires means, okay, going beyond the objectives of the memorandum of association. So in such case, the investors may get injunction order from the court. Okay, now another one is breach of warranty. Okay, breach of warranty. So what does breach of warranty of authority means? When an agent exceeds his authority, okay, he is personally liable for breach of warranty of authority in a suit by the third party. Okay, means if at all even though they are not having the authority, okay, but they have entered into a contract, means it is considered as breach of warranty of authority. Okay, and also that particular person is personally liable for that breach of warranty of authority, okay, in a suit by the third party. So now, for example, the directors of a company are its agents, we can consider, okay, and as such must act within the limits of they must act according to the limits of the company's powers. So if they induce, however innocently, an outsider to enter into a contract, means which is ultra vires, so the company, that they will be personally liable to the third party for his loss. Okay, here in this case, the directors will personally liable to the third party because intentionally they induce the third party or else outsider by using the outsider's innocence, they induce into the contract, okay, and use their power, okay, exceeds, even though they do not have the authority or power, they use that power, means, okay, they are personally liable. This is known as breach of warranty of authority. Okay, for example, a railway company had already exhausted its borrowing powers. Okay, again I'm saying a railway company had already exhausted its borrowing powers, means it cannot borrow, okay, from the creditors. So the directors of the company invited proposals from a loan on debentures. Okay, debentures are nothing but giving debentures to the debenture holders and getting loan from them. Okay, so getting money from them and giving interest for that amount. Okay, so Mr. Week offered a loan of 500 pounds, okay, which was accepted, and debentures were also issued at that time. Then the loan being ultra vires. Why? Because the company already exhausted its borrowing powers. So definitely, even though the directors invited debentures, okay, and issued debentures also, the loan is considered as ultra vires, okay, and held it to be void. Okay, but because the directors inserting the advertisement had warranted that they had the power to borrow, which in fact they had not also, here the directors will personally liable for the breach of warranty. Okay, so this is breach of warranty of authority. Coming to another effect or consequence, means personal liability of directors. So personal liability of directors means the funds of company can only be used for authorized objectives. Okay, so in case if any director makes any unauthorized payment, okay, he will be compelled to refund the money to the company. The director will be personally liable for any loss suffered by the company due to him. So this is about the personal liability of directors. Means unauthorized payment should not be done by the directors. If at all unauthorized payment is done by the directors, they are compelled to refund that money, and also, okay, they are personally liable for any loss suffered by the company due to him. And the other one is ultra vires contracts. means any contract by the company officials outside its scope is completely void, okay, and it has no legal effect. That is known as ultra vires contract, okay. Means the company officials, the persons who are within the company, associated with the company, the officials of the company, okay, they don't have the powers, okay, but uh, they exercised, okay, but they exercised outside their scope, means, okay, if at all they entered into contract outside their scope, okay, then it is completely void and it has no legal effect also, okay. And another one is ultra vires acquired property. It means that if the money has been spent on purchasing ultra vires property, okay, the company will have the secured right over the property. If the property is legally and formally transferred, it will become the asset of the company, even though the company was not entitled to acquire such property, okay. So here this is related to the property, okay. So even though it is ultra vires, but the company will have secured right over the property. Why? Because it is legally and formally transferred, then it will become the asset of the company. If at all that property, even though it is ultra vires beyond the powers of memorandum of association, okay, but it is legally, the property is legally and formally transferred, means that it will become the asset of the company, okay, even though the company was not entitled to acquire such property. So this is another effect regarding the doctrine of ultra vires, okay. So another one is ultra vires borrowing, where a person lends money to a company and the company either has no borrowing power, okay, or has already exceeded them, or the borrowing is for the purpose which is ultra vires, then the contract of the loan is void and no action can be brought under it to recover the money lent. So in previous case I have said this one, okay, regarding the director's case, okay. Here this director's case we have discussed, but ultra vires borrowing means this is related to the company, means where a person lends money to a company. If any person lends a money to the company, and company either has, even though the company is not having the borrowing power, okay, or else it has already exceeded that power, means even though borrowing is done, means, okay, then the contract of loan is considered as void, okay. And also the person who lends the money to that company is there, no, so that person, he cannot recover the money, okay. So where the company has used the loan to pay off intra vires debts, the lender can take the place of the original creditor and enforce the same rights here, okay. And the last one is ultra vires torts. This means that a company, we can say in two types, company liable and company cannot be liable, okay. Company cannot be liable in case where any tort is nothing but civil wrongs, okay. So if any tort or else a civil wrong is committed by its officers in connection with business outside, okay, business outside its scope of objectives, means the company cannot be liable, okay. Or if officers have performed an activity in course of which the tort was committed fall within the scope of MOA, means it is not outside MOA, it is within the boundaries of MOA, means then the company will be held liable, okay. Now coming to exceptions, okay, exceptions to doctrine of ultra vires. First one is if the company has made any ultra vires lending, okay, it has the right to recover the amount from the borrower, okay. Exceptions, these are exceptions. Actually doctrine of ultra vires means the case is void, okay, it is illegitimate. So illegitimate means it cannot stand in the court of law. But there are some exceptions. Okay, so the exceptions are those: if company has made any ultra vires lending, company lends, okay, so it has the right to recover the amount from the borrower. Why? Because in first memorandum of association introduction part only, we have studied that outsiders should know the objectives, or else they have to know the memorandum of association, then only they have to enter into contract. Why? Because a memorandum of association is a public document, it is their responsibility to see. So in this case it will be applied here. Okay, so this is the first exception. Now coming to second exception: if the company has acquired any property under ultra vires contract, the company's right over such a property shall still be secured. Okay, so this is also the same aspect. Above one is related to the lending of money, but the second one is related to the property. Okay, both can be recovered, both can be the second one, the property, regarding to property issue, company has the full right over such property, and it still be secured. Third aspect: an act with ultra vires the articles but intra vires the memorandum of the company, then articles may be altered and included in the acts of the company. What does this mean? So we have memorandum of association, articles of association. Memorandum of association deals with the outdoor management, or else outside of the company. Articles is related to the indoor management, or else within the company. And memorandum of association cannot be altered, it is a hectic job. Through the permission from central government only, the memorandum of association can be altered. But coming to articles of association, as it is indoor management and within the company aspects, okay, articles may be altered. So therefore, if an act is ultra vires of not memorandum but ultra vires of articles, okay, but intra vires with the memorandum of company, means within the beyond the limits of the memorandum of association of the company, but ultra vires regarding the articles, means, okay, here it is exception is given to doctrine of ultra vires, means articles may be altered and they can be included in memorandum of association. Why? Because this article of association is a subset of a memorandum of association, okay, and means it is a subsidiary for a memorandum of association. Coming to fourth one: an act which is intra vires the company but outside the authority of directors may be ratified by the shareholders in proper form. So another case is that intra vires means having the power, okay, within the company, okay. Here ultra means beyond, intra means within the company. So vires is nothing but the powers, so powers within the company, okay, but outside authority of directors, okay, the authority of directors will be connected with the outdoor management. So how outdoor management or authority of directors outside can be included in the memorandum of association, means it cannot be treated as ultra vires, means by the ratification of the shareholders in a proper form, okay, by resolution of the shareholders form, okay, this can be treated as the intra vires. So this is another exception. So regarding the authority of the directors, so why? Because even though authority of directors is outside, but it is related to within the company, within the memorandum of association, within the company, intra vires. So this is treated as not ultra vires, okay. So if the fifth one is, if the act is intra vires the company but it is done in an irregular manner, okay, it can be validated by the consent of the shareholders. So this is the last one. Even though the act is intra vires is nothing but the powers within the company only, they have acted according to the memorandum of associations beyond the limits of the provisions of the company law only, but it is done in an irregular manner, okay. In such case exception is given, it is not treated as ultra vires, okay, it can be validated by the consent of shareholders and done it in a regular manner, okay. So this is about the exceptions of the doctrine of ultra vires. So this is the concept regarding the ultra vires, okay. So this is doctrine of ultra vires. which is studied under the head of Memorandum of Association under Objective Clause. Okay.